Yeah. If you want to sit beside me over here, even right here, you'll be able to see me too. It's all right. Don't worry about that. God, that's a weird angle. That's right. Connor, hey, Tommy.
Yes, sir.
Can I just put the laptop on the podium?
Absolutely.
And use the camera on it. Is there a camera on this?
There is a camera.
Yeah. Thanks. No. I don't have the video. There it is.
Cheryl, we can't hear you.
I'm sorry. Oh, yay, oh, yay, oh, yay. The Honorable Court of Appeals for the 11th District of Texas is now in session.
Thank you, Ms. Busk. Good afternoon.
Good afternoon.
I hope each of you are in a dry place. We've had a monsoon here of sorts. If we looked extra damp, it's because we may have got rained on at lunch. But with that being said, we're ready to proceed with our next case. At this time, the court will call cause number 11-20-229 City of Odessa versus AIM Media Texas, doing business as the Odessa American. To let you know before we start the argument, my name is John Bailey. I'm the Chief Justice here on the Court of Appeals. I'm joined by Justice Stacy Trotter, who comes to the court from Odessa, and Justice Bruce Williams, who comes to the court from Midland. We have read your briefs. We're thoroughly familiar with the case, and we look forward to receiving your arguments in it today. Ms. Brooks, are you ready to proceed?
Yes, Chief Justice.
You may.
May it please the court. My name is Natasha Brooks, and I'm the city attorney for the city of Odessa. I will be representing the city of Odessa as the appellant in this matter today. The issue presented in this case is whether the trial court erred in denying the city of Odessa's plea to the jurisdiction when the Odessa American failed to establish any of the requirements under Section 552-321 of the Texas Public Information Act to properly waive the city of Odessa's governmental immunity. The legislator was clear in their intent to uphold governmental immunity unless specific circumstances applied. Section 552-321 of the Texas Public Information Act provides that a requester like the OA may seek mandamus relief, compelling a governmental body to make information available for public inspection if the governmental body, 1, refuses to seek an attorney general decision, 2, refuses to release public information, or 3, refuses to release information in accordance with an attorney general decision. Further, courts have ruled that the types of relief expressly made available by statute operate as the boundaries for a statute's waiver of immunity.
Ms. Brooks, as we understand your challenge, and I think it's also indicated by the hearing transcript that this is a pleadings challenge. That's the basis. That was the basis of your plea to jurisdiction.
Yes.
And that essentially your claim is that the Odessa American did not allege an adequate cause of action because they did not specifically allege any non-compliance request. Is that correct?
Yes, that's correct. Under 552-321, the mandamus relief.
So when we look at the pleadings and we have to construe them liberally in favor of the Odessa American,
Mm-hmm.
Can you point to us in the pleadings where you claim there hasn't been a sufficient cause of action alleged?
Yes. Oh, in the Carrasco and Ferguson cases, Your Honor.
But it's not necessarily a specific case that you're claiming. I'm asking,
Oh,
in the pleading that has been filed on behalf of the Odessa American, which the city challenged as being inadequate,
uh-huh.
where can you point us to the inadequacies in that pleading?
In their pleading or?
Yeah.
Okay. Give me 1 minute.
Because I'm sure you know that in this scenario, we're not necessarily addressing the merits of the claim that's alleged. It's just whether the trial court has subject matter jurisdiction based on what has been asserted in the pleading, correct?
Okay, so on page 16, where the city of Odessa redacts information in police reports and probable cause affidavits according to statutory exceptions with the guidance of the Attorney General. And so in the appellee's first amended petition, they claim that it claims case report for the arrest of Lily Ferguson and Abel Carrasco were unlawfully redacted. But in both of those,
What specific documents were withheld?
there were no specific documents withheld.
Well, then what specific documents were redacted?
The Abel Carrasco documents were that the documents that they're claiming are, they were PC affidavits, and one was in Abel Carrasco and the other one was Lily Ferguson. And those were the documents that were redacted.
So in both of those cases, probable cause affidavits that were a part of a search warrant were redacted prior to disclosure to the Odessa American?
At the time, they were not part of a search warrant. At that time,
The probable
yes,
cause affidavit?
at that time, they were not part of a search warrant. They weren't signed by a judge or attached to an arrest warrant at that time.
So after the warrant was executed, was there a subsequent request for the disclosure of that probable cause affidavit?
No. If that was the case, that would, the court would have had control of that record under Rule 12.
And that would have been required to be produced, correct? Because that's public
Yes.
disclosure information.
Yes, after the warrant, yes.
Ms. Brooks, I believe that the newspaper has focused in on their paragraph 14 of their first amended original petition. Is that paragraph in and of itself sufficiently pled a cause under the statute? What is your response to paragraph 14?
Let me, and what they plead, they're conclusory statements. And so there's nothing to back up what they're pleading because we don't withhold anything that's not public information or that we haven't sought an attorney general opinion for. But I'm gonna pull their pleadings. Okay. So my camera fell. I apologize.
No worries.
Okay. So paragraph 14 is the shootings, the 2019 shootings. And they don't plead anything under 552321 to waive our governmental immunity in that claim. So.
Well, the sentence is, since the 2019 shootings, however, the city has taken several steps that have interfered with and violated with its duties to promptly provide basic information.
And that's actually, Okay, and that's actually false. What happened is when
We're
I
not, we're not talking about the veracity of them, are we?
right. But that's not true though. We haven't taken steps to delay or since August of, I lost that, of 2019. They did receive the information, and for context under these is this was a voluminous request. And so the information that the city had to parse through for these requests, we had 220 pages of police report, 250 dash cam, body cam videos, 513 calls made to 911, emails and text messages from all police officers, high-ranking city officials. Further complicating the matter, the FBI and the DPS, they took possession of the records. So it was a voluminous request, and it did take us longer than most cases to produce these records. But under the Public Information Act, promptly, one of the requirements is the volume of the information. And so, yes, that did take us a while to produce, but we did produce it to the Odessa American, and they haven't specifically identified any instance in which the city has refused to request an attorney general's decision, because we did. And they acknowledged that the city released the information at issue in the request. They haven't shown the court any examples where we did not release this information to them. In addition, because we had 39 requests from 22 requesters in that instance, we released all the information. The Odessa American only has requested specific information, but we released to them all the information that we released to other requesters.
So what's in dispute as far as what has been withheld?
I don't know what's in dispute, and I think that's one of the questions we have. We don't know what the Odessa American is seeking. You know, under 552321, we are, you know, the relief is disclosure, and we have disclosed these documents to them. So that's the big question. We don't know what they're seeking. They have the public information.
So this voluminous request that pertain to the 2019 shootings, is it your position that executed probable cause affidavits, police reports, anything that would have been involved in a closed case were produced?
Yes, yes, it was all produced to them. The AG ruled everything but basic information, and we released all of that to the Odessa American. Even we just sent the same amount of information to every requester, so they even got more information. And of course, all of the blotter sheets and everything were released through the police department.
And was any of this information redacted?
Yes, yes, information, whatever the Attorney General ruled in that ruling was redacted. They told us to release basic information, and we did.
So you released what was advised to you by the Attorney General's office?
Yes, we released according to the Attorney General's office, and we relied on the Attorney General's office ruling when we released that information.
And did the Attorney General direct you to redact certain information from those documents?
Yes, yes. And I can't remember with this request, because a lot of times they will mark it in red exactly what to redact. And then in this instance, I think they had some of it marked. It was a lot of information. And when we go through those videos and those audios, you know, we have to go through each one of those. And so it did take some time. This is a very unique situation.
Well, is it the City of Odessa's policy that with every Public Information Act request of this nature that you seek guidance from the Attorney General as to what should or should not be disclosed?
Well, if we're going to redact any information, we do submit that to the Attorney General. But what we normally do is information that we deem as public information, we always redact and release. And so before we submit anything to the Attorney General, we redact that information and we give that to the requester. If we deem nothing needs to be redacted, we'll also give that to the requester. But in cases like this one, where there's exceptions, we do redact and release. So the requester always has something to go by until we get an Attorney General ruling on only the exceptions.
But essentially, you're making an independent determination as to what you believe should be redacted before disclosure?
Yes, in the beginning, so that they, you know, the Odessa American can have something to go by to have their story. Yes, we do. And the Attorney General is okay with that. And when we submit it to the Attorney General, we let the Attorney General know we submit a redacted copy that we redacted. And we also submit the unredacted copy so they could know what we provided to the requester.
Ms. Brooks, is it the city's position that the newspaper can only complain about specific past requests, or can they use a suit for mandamus under 552-321 as sort of a prophylactic to get guidance on future requests?
No, we don't think that they can sue under 552-321 for future requests. Those are prospective in nature only. And so when they're trying to sue for prospective requests, I think they're asking this court, you know, to rule something in the future that we have no idea to the extent of what, you know, would be ruled. We provide public information, and if you'll look at the evidence that they provided, you will see that we provide public information. And so under the mandamus action 552-321, we don't think they pled anything to waive our governmental immunity. And so the court did not have subject matter jurisdiction because it should not be prospective in nature. And all the previous cases were you know, in other case law, specific case law, if you'll read our pleadings, in other case law, they always requested specific information. If you look at that, they asked for emails, you know, for a coach that had been fired. It's always specific information that they are seeking, that the plaintiffs are seeking. And in this case, we don't even know what the plaintiffs are seeking because we have released public information to them. And all of these requests have been released to them.
Does that conclude your argument?
Well, no, let me move on.
Okay. Well, the legislator was clear in their intent to uphold governmental immunity unless specific circumstances applied. So Section 552-321 of the Texas Public Information Act provides that a requester like the OA may seek mandamus relief, compelling a governmental body to make information available for public inspection. If we refuse to seek an attorney general decision, refuse to release public information, or 3, refuse to release information in accordance with an attorney general's decision. To date, the Odessa American has not specifically identified any instance in which the city of Odessa has refused or been unwilling to request an attorney general's decision to supply public information.
But as you said earlier, you claim, or it's the city's position that the Odessa American suit fails because the city's immunity has not been waived under the act. Is that correct?
Yes, that's what the city is claiming.
Okay.
And finally,
how is the city's immunity not waived?
Because they have done nothing under 552-321 to show that they have waived our immunity. And not only that, all of the only relief that they would be provided is public inspection. And they have received all of the information that they have requested. And so the relief provided to them would be public inspection. And as you can tell by even the evidence that they give you, they have inspected all of the records. They're not claiming we have not given them the records.
I think we can safely assume that if the city had produced everything to the Odessa American satisfaction, this proceeding would not be occurring today.
Well, I think if we produce it to their satisfaction, which I believe is unfettered access is what they want, then this proceeding would not be, we would not be here today because we produce public information to them. And they haven't requested relief provided with the confines of section 552321. The courts have made it clear that the types of relief expressly made available by statute operate as the boundaries for a statute's waiver. The OA seeks mandamus relief to compel the city to comply with the Public Information Act by promptly producing public information. In the Gates case, the Third Court of Appeals made it clear that the substantive relief provided by the Public Information Act is limited to the release of information. Here, the OA is not asking the city to make information available for public inspection. The Odessa Americans' request for relief is prospective in nature only. They request that the city follow the law, but have yet to provide any examples where we have not followed the law. They haven't pointed to a single document or a piece of specific information that the city could make available. In all the records and examples they allege and provide for the court, they acknowledge receipt of information. They're not asking the city to disclose certain information under 552321. It seems that they're asking for future relief, production of documents or information yet to be identified or not even in existence. Based on these facts, the city's immunity from suit has not been waived because the OA did not seek the type of relief available within the scope of the waiver. And the OA had a chance to cure their pleadings. The city filed special exceptions pointing out the deficiencies in the pleadings, and the Odessa Americans' amended pleadings still failed to establish any of the three requirements to properly waive the city of Odessa's governmental immunity.
Ms. Brooks, was a hearing held on the special exceptions?
No.
So you don't have a hearing, you don't have a ruling on those?
No, we don't have a ruling, but we did point out the deficiencies. We filed them.
So if there hasn't been a hearing or ruling, then what effect does that have on the appellate process?
That the Odessa American had notice of the city trying to figure out exactly what they were seeking.
Okay.
Did you seek a hearing on your special exceptions?
No, I think that they were.
No, I think we were going to take that up in the first hearing, but all that we heard was the plea to the jurisdiction.
And what relief is it that you claim the Odessa American should have sought?
They should have sought public inspection. That's what the statute says under 552321. So if they were looking for something specific, they should have asked for the documents that they were looking for, the public information specifically that they were looking for.
All right, any other judges have anything else? You're out of time, Ms. Brooks. So we'll come back to you for a 5-minute rebuttal here at the end. Thank you.
Thank you.
May it please the court?
Yes.
I hope I'm not on mute. I'm Jeff Nobles, and sitting beside me in my office is John Bussian from North Carolina. John has been, I think, effectively general counsel for the Odessa American for a long time, and I've worked with John on these cases in Texas. He was kind enough to come here today so we could both be here, but unless he grabs the microphone for me, I'm going to do the talking. The city's argument reminds me that when I met Judge Glenn Harrison in Sweetwater in 2003, the first thing he said to me about my client's conduct and discovery is, what we seem to have here is a failure to communicate. And he put my client in the box after that, so it was not a pleasant day. I think it's fair to say that we're having a communications problem with the city of Odessa. And when I say that, I'm speaking primarily of the newspaper. This case is at the pleading stage. We have not had a single evidentiary hearing in this case. We haven't had a chance to put on any evidence because the city filed a plea to the jurisdiction which short-circuited evidence that could have been heard in October, but at the city's insistence, the plea to the jurisdiction was heard. It was correctly denied, and we've been on appeal since that time.
Mr. Nobles, what's your position on whether or not the city's immunity has been waived?
Well, two things, Justice Trotter. The first one is that the Public Information Act is an express waiver of immunity for governmental bodies in Texas with regard to its subject matter. And I've got 552.321 on my phone here. There are 3 different ways that immunity can be waived under the PIA. 3321 subsection A says, first, if the governmental body refuses to request an attorney general's decision, that's not relevant here. But if it refuses to supply public information, that is the second way in which immunity is waived under the Act. The third one we also aren't claiming under. But as our brief makes clear, we have sought the production of public information that the city has refused to produce in the past, and to my knowledge, continues to produce. In a sense, we're frozen in time here because our petition was filed in early 2020. We amended it in early 2020. The COVID pandemic and the recusal of the trial judge prevented us from having a hearing until October. And all we've had is a very short hearing on the state of our pleadings. Our pleadings do state in 3 different places ways in which the city does not have immunity because it has, construing our petition in the way it has to be construed, the city has waived its immunity in 3 different ways. The court has cited paragraph 14 of our first amended petition. I'd also refer the court to paragraph 6, where we say that the city has refused to provide public documents without redacting information that is public information. And in paragraph 6, paragraphs 25 and 26, we allege that the city has violated ministerial duties and it has unlawfully refused to supply public information. And in the second answer to your question, Justice Trotter, is that governmental entities don't have, and governmental officials, they don't have immunity from complying with the law. If the law imposes a ministerial duty, there's no sovereign immunity that prevents a mandamus action to compel them to comply. The PIA provides a summary mandamus remedy. This is supposed to be quick and easy. We're supposed to have a refusal under the PIA. A mandamus can be filed in the district court. The case law says that that's not a regular proceeding. It's an extraordinary writ that compels the city in this case to comply with its duties under the PIA. We've been trying since more than a year ago to get the city to follow the law that was outlined in the cases that we cite in our brief, outlined in the PIA, and is also effective as a consequence of the First Amendment. Is the 14th Court of Appeals held in the first City of Houston versus Houston Chronicle case. Our brief calls it Houston Chronicle 1. Houston Chronicle 1 has become the black letter law in this area. In Public Information Act cases, the Attorney General cites the types of basic information that have to be produced on a request. This is not an evidentiary argument. Many of the city's arguments today are evidentiary arguments that I have heard for the first time. We haven't had a chance to talk about the merits of the case. We're talking about our pleadings. And on their face, our pleadings certainly allege a cause of action that waives the city's immunity under the PIA. We've also
Mr. Nobles, Ms. Brooks has stated that the Odessa American's request was essentially a voluminous global request without any specificity. How do you respond to that?
I disagree with that on the facts. Now, I'm not the reporter on the ground. I'm not the witness who can tell you what all the facts are, but our response is that the city changed its policy with regard to the production of these documents in 2019. Previously, the city had complied with the law. After that, it did not. Our petition is based on specific documents that don't comply with the law that was set out in Houston Chronicle 1. Later in the case, we filed a summary judgment motion trying to get a ruling, trying to get the ruling we're entitled to, and we included 50 more examples of documents that weren't produced. We haven't made voluminous requests. My understanding from talking to the newspaper, this is outside the record, but my understanding is that this is based on our beat reporter for the Odessa American trying to get basic information about a crime that's been committed. And previously, that information was forthcoming.
And Ms. Brooks had mentioned that there were requests by the Odessa American for the production of probable cause affidavits prior to execution. Is that right?
As an evidentiary matter, I'm not a witness, Your Honor. I can't say. I would say that's an evidentiary issue that goes to the merits. It certainly is not a allegation that is relative to our plea to the jurisdiction posture that we're in right now. I just don't know the truthful answer to that. I will say that our requests are not voluminous in individual cases. We have asked for basic information that the PIA requires to be produced under the case law. And that includes the arrestee's name, most importantly, the specific circumstances, a detailed description of the charge. That's the most noteworthy thing. The two documents that the city referred to in their argument are the Ferguson and the Carrasco PC affidavits. In those affidavits, you can see that what was produced quickly to us had the circumstances of the arrest completely redacted, and therefore it's not newsworthy. This court held in the Sotelo case, which we brought to this court in 2006, Chief Justice Jim Wright, who was then new to that job after Judge Arnott had moved to Houston. Chief Justice Jim Wright wrote that it's very important to the public interest that information regarding all types of offenses be available. The cases say that information quickly becomes stale. If the basic information about a crime is available to a reporter, that information includes the arresting officer.
And the probable cause affidavit that you're referring to, had it been executed when it was produced?
I can't tell, Your Honor, because it was redacted. Almost the entire document is blacked out. Whether that particular warrant had been issued or not, we had a copy of it. And the information that's in it is the basic information about a crime that the city police department traditionally provides and stopped providing in 2019. We're not asking for voluminous production of videotapes and other stuff. At the outset of the crimes commission, this is what their duty is. It says that the city must adopt policies and practices that require it to keep this information. This is quoting Houston Chronicle 1, 531 Southwest 2nd at 187. That basic information should be immediately available at a convenient central location. It's the police blotter, essentially. It can be PC affidavits. It can be other documents that contain basic information. But if reporters are allowed to see the police blotter daily, they can do their job. If the information in that blotter isn't produced, if it's redacted, then there's a breakdown in communication between the city and the police department.
With these probable cause affidavits that you claim were redacted improperly, was there any effort by the Odessa American to seek disclosure of this information from either a district court or the district clerk's office in Ector County?
Well, there certainly were communications and negotiations with the city that didn't rise to litigation. We had months of discussions with the city about it wasn't the lawyers, it was the newspaper itself, the editors and reporters talk to their friends at the police department and their friends at the city about what they could do to solve this problem. We filed this mandamus action seeking the production of the documents that should have been produced, including PC affidavits that had improper redactions. There may be other ways to get that information. The PIA says that the best way is the mandamus that's available under the PIA. And in my experience, uh, that never turns into the type of gotcha game that we seem to be playing here, where we can't seem to, in the city's opinion, ask for the right thing. Our brief makes it clear. We try to make it clear for the city. Uh, there may be motivated thinking that's keeping the two sides, particularly on the city side, from communicating. So what we're asking this court for is a clear opinion about what the duties are. I wanted to talk uh, very briefly about a couple of things. First, the city objects to summary judgment evidence that is not part of the clerk's record. We requested a supplemental clerk's record that was filed in this court on April 5th. So everything is in the record before this court, and it's in the clerk's record. It also was all filed in the trial court as part of our summary judgment evidence. The city has changed law firms. They represent themselves now. They had a law firm representing them in October, but all of that stuff was served to that law firm, and it's a public record that all of the things that we have asked for, there's 50 examples of requests for documents that weren't satisfied because we didn't receive the basic public information that the Texas PIA and the cases that construe it say that we're entitled to have. It's uncontroverted that those documents were not produced, or if they were produced, they were produced with redactions that were improper. There's one particular example. Right before the summary judgment hearing, we had requested an offense report, and we were contacted by someone at the city saying that we can't produce any of this unless you agree in advance that our redactions are proper. We couldn't agree to that. And so those documents were absolutely withheld. That's in the record. A document that should have been produced was not produced. Our allegations are sufficient to state a cause of action that waives immunity. And beyond that, the evidence attached to our summary judgment affidavit, which has not yet been heard by the trial court, and other documents continue to be withheld. It's not totally clear to me, but the city's reply brief seems to say that they're not going to change the way that they do things. They're not going to provide basic public information to us immediately at a convenient central location, as the Houston Chronicle 1 case says is their duty. Houston Chronicle 1 based its conclusions about that on the language of the Open Records Act, which is now the PIA. Also on the First Amendment, which obviously preceded the adoption of the Open Records Act. Under First Amendment principles, these documents also have to be immediately available. It's not supposed to be this hard for the newspaper to do its job. In the Sotelo case in 2006, Chief Justice Wright described a situation where the city actually released a press release that made it possible for us to report on a fairly controversial number of arrests of sex offenders. That type of cooperation serves the public. This type of adversarial relationship not only hurts the interest of the newspaper, it may help the lawyers, but it doesn't help the public, and it doesn't help the newspaper. It is not hard to comply with the requirements of the PIA. When a crime is committed, the basic information that's laid out in Houston Chronicle 1 is supposed to be made immediately available. If there are extenuating circumstances, I don't believe that our position as a newspaper has ever been unreasonable, but to blockade and to bottleneck and to embargo that information until the Attorney General has had at least the weeks required for a very fast Attorney General's opinion that cuts down the flow of information in way that the PIA, the Public Information Act, is supposed to ensure doesn't happen. And I don't think we're enemies in any sense of opposing counsel. I don't believe that my client is an enemy of the city, but I do believe that there's been a basic failure of communication here over what we're asking for. As far as our petition alleges, the only thing we're requesting is that basic information, which is about 10 basic items that the Houston Chronicle 1 case described as being the police blotter. That's all we're asking for. We're in the internet age, things are online. It may be that the police blotter isn't the same thing it was then. That should make it easier for the city to have a procedure for providing that basic public information to the public as well as the media on a at least a daily basis, as the PIA itself says, within the ordinary business hours of the governmental entity. They're supposed to have that basic information available in a central location. I want to address briefly this future relief theory that the city has made. Our allegations are based on information that has been withheld in the past. We don't have an evidentiary record that shows whether all of that has been produced. There certainly are things that were not produced yet at the time of the summary judgment hearing. An opinion from a court that explains clearly to the city what its duties are will perform a valuable service to the public and to the citizens of Texas, as well as the parties in this case. All the city has to do is to keep that basic information available on a daily basis immediately. And it's not videotapes, it's not voluminous requests. It is a ministerial duty in the words of the case law that the city has to comply with. It's
Mr.
not,
Nobles, you mentioned that at some point in 2019, there was a change in the city's policy
yes,
as to the method that they would follow in producing what you consider to be public information. Is that right?
that's my understanding. And I think that's the same thing that the city's briefing in this case.
So prior to 2019, the Odessa American had not encountered any difficulty in obtaining the information that was requested?
Well, I'm not a witness. I don't want to overstate what I know, but my impression is there was not a general problem. There are always problems in life, but this was not a recurring problem. It's a problem that first developed in late 2019. And it's
Do you know what precipitated the change in policy?
I believe, in fairness to everyone, it was the Odessa shooting when a terribly notorious and terribly tragic thing happened. And there may have been a great deal of information. I think this is what Ms. Brooks said. It was a lot of information, but that resulted, from all appearances, in a change. We don't know. We have filed a pleading. We've had some conversations that resulted in the change that brings us to this court today, seeking the relief that the PIA entitles us to. This is the city's appeal from a plea to the jurisdiction. They have a right to appeal, but clearly this is not a case where sovereign immunity is a genuine issue. And we would ask that the court affirm the trial court's order for that reason.
Thank you, Mr. Nobles. Rarely is someone able to finish right on the dot. You were able to do that. I'm impressed. So with that, the clock's been reset to 5 minutes. Ms. Brooks, you'll have up to 5 minutes for rebuttal.
Thank you. I just want to point out that the case Houston Chronicle 1 has been codified into the Texas Government Code 552. So things like a central location, that's no longer. Under 552, 234, and 235, those give the proper methods to submit a public information request. 552, 234 through 552, 235. Now we have provided all of that information as required under the Act on our website, and they can either email us or go through our GovQA portal. So that information has definitely changed. Further, the city has a duty to segregate public information from confidential information or information that's otherwise disclosed. And so that's under the Texas Administrative Code, section 70.11. There is a police blotter that the Odessa American still gets their information from. However, that's under Ector County, not the city of Odessa. So there is a police blotter that they still have. It's not the city of Odessa's. And police matters are an appropriate ground on which to file a suit of mandamus. Yet policy matters are an appropriate ground is not an appropriate ground on which to file a suit for mandamus. We, under the Texas Administrative Code, can change our policies, and even under the Public Information Act, we're required to adopt policies and procedures for others to follow. I want to talk about the threat that they allege. The Attorney General allows for a requester to permit a governmental body to redact information without requesting an Attorney General decision in order to streamline requests. So if you'll look at that in the pleadings that they submitted as a threat, what we do is they were requesting juvenile information. And as you know, juvenile information is subject to an exception. And so what the Attorney General has allowed us to do is we can ask them to not, if they would allow us to redact that information, and we can get that report to them sooner. And so that's what we were doing. It was not a threat.
What precipitated this alleged change in policy as far as the city's position in disclosing requested information?
What happened is we started training in August of 2019 before I was the city attorney, because we lost the police legal advisor. And so we started doing a lot of training. They went to training in December. And so when we came back and we started training other departments, the PC affidavits was brought up before arrest and before signed by a judge. And we just started reviewing those to make sure no information was disclosed that was subject to an exception. That's how it came about. It had nothing to do with August 31st, but that's been the narrative.
In other words, your predecessors were doing it wrong?
Well, the court, I think the court thought that it was a court document, and it is after the arrest warrant is signed. So I think that's what happened. And, you know, we are allowed to redact. That's why we have Attorney General's decisions on everything that we have redacted. And so we are allowed to do that under the act. And so the OA is not asking us for information for public inspections as they should. The OA's request for relief is prospective in nature. They're asking us to follow the law. And so we just ask that the court know that the city is immune to this suit and the trial court lacks subject matter jurisdiction to proceed. And
Well, you don't have immunity if you're violating the statute, do you?
we're not violating the statute. We're complying with the Public Information Act.
That's not answering my question. My question is, if you are violating Section 552, that would not entitle you to immunity, would it?
Well, those are three specific things that they would have to allege to pierce our governmental immunity, and they have not alleged those three specific things.
Does that wrap it up?
Oh, I was waiting. I thought he was going to ask another question. The court should find as a matter of law that the Odessa American failed to establish one of the three requirements under Section 552321 of the Texas Public Information Act to properly waive the city's of Odessa's governmental immunity. And that wraps it up.
Okay, all right. Thank you very much. We appreciate your patience in stumbling through some of the technology. Computers are great sometimes and sometimes not. But we will, your case has now been submitted, and we'll